All right, Mr. Biggs, am I live on YouTube? Okay, let's go on the record on cause number DC 1818044, Alonzo versus FCI Lender Services. Counsel, make your appearances.
Your Honor, Dustin George for defendant BPL Funding 2 LLC in the movement.
Your Honor, Tim McDaniel, also here for BPL.
Maureen Kersey here for Liddell Bugs and 316 Capital.
Candace Haley here for the plaintiffs.
Okay, let's go ahead and get started. We're hearing a motion to dissolve.
Yes, Your Honor. As you mentioned, we're here on BPL Funding's motion to modify or alternatively to dissolve the temporary injunction that's in place in this case. This case involves the property at 342 Mantlebrook Drive in Dallas, Texas. Defendant 316 Capital took out a loan to purchase this property from my client with a one-year term. That was back in 2017. My client was not aware at the time that 316 Capital had already reached an agreement to sell the property to plaintiffs with the wraparound transaction with a 30-year term. BPL's deed of trust contained a due on sale clause, and upon discovering that the transfer to plaintiffs, BPL demanded immediate payment in full from 316 Capital. And when payment was not made, BPL scheduled a foreclosure sale for December 2018. BPL was then restrained from conducting the foreclosure sale by a temporary restraining order obtained by plaintiffs upon filing this lawsuit. The parties attempted to settle the matter for a number of months, extending the TRO by agreement during that time. And when no agreement could be reached, a hearing on the application for temporary injunction was held and an order was entered on April 26, 2019. That injunction restrained my client BPL from enforcing its deed of trust lien against the property and has done so since April of 2019, so over 2 years. During this time, the plaintiffs have had record ownership of the property and possession of the property. However, they have not paid any of the taxes on the property during this time. Taxes for 2019 and 2020 are currently past due and accruing interest, penalties, and now collection fees. I believe the collection fees are being accrued on the 2019 taxes, and over $5,000 in penalties are now due. The plaintiffs in this case own other properties in Dallas, but they have been paying the taxes on those properties. When I spoke with plaintiffs' counsel regarding, my request that they pay these taxes to avoid the property being foreclosed on by the taxing entities, she advised that they have no obligation to pay the taxes because defendant 316 Capital, through its principal Liddell Bugs, had told them not to pay the taxes. Nowhere in their response to plaintiff side authority for the proposition that their obligation to pay taxes is relieved because a third party told them not to. I don't think there's any dispute that they own this property and that they are obligated to pay these taxes. The purpose of an injunction is to preserve the status quo and to protect the subject of the litigation pending the ultimate result in the lawsuit. Here, that is the property, the subject of the litigation, and plaintiff's failure to pay the taxes is putting the property in jeopardy of being foreclosed on by the taxing entities. Plaintiffs have filed a response, which I read quickly this morning. They highlight in their response that trial is only 2 months away. While that is true, I believe trial is September 14th. The injunction is expressly in place through final judgment and any appeal. If a trial goes forward in September, post-judgment motions and appeal could last well into 2022, by which time taxing entities would certainly sue to foreclose and to recover taxes from the prior 3 years. Based on this, my client respectfully requests that the court modify the injunction to require the plaintiffs to pay the 2019 and 2020 taxes and related interest, penalties, and collection fees immediately, and to continue making payments into the court registry each month for the proportionate amount of taxes that's accruing in 2021, and to the extent that this matter continues into 2022 also at that time. I've submitted a proposed order, Your Honor, that provides for both options, the dissolution of the injunction and also a modification. And I've tried my best to set forth, the method by which they pay, the timing, and then what happens if they don't. Based on all of this, I asked the court to modify, or if the plaintiffs are unwilling to or refuse to pay the past due taxes, dissolve the injunction so my client can proceed with enforcing its interest and avoiding the taxing entities foreclosing on this property and wiping out the subject of the litigation. Thank you.
All right, response?
Yes, Your Honor. So on April 26th of 2019, we did have a temporary injunction hearing. At that time, the court granted the temporary injunction hearing. And at that same hearing, Liddell Buggs, who's the principal or the owner of 316 Capital, which is the mortgage company in this case for the plaintiffs, actually said on record that instructed the plaintiffs not to cease from making any further payments to them until there's a resolution to this case. So that was in April of 2019. Fast forward, we had a summary judgment hearing December 7th of 2020. And at that hearing, the court denied the summary judgment motion against the defendants. And at that same time, the tax issues were addressed. And at that time, this is the reason we actually were trying to have a court date for February via Zoom, but none of the attorneys would waive jury. And so the earliest that we could get in to have a trial was September the 14th of 2021. Initially it was November, but we were able to somehow get in for September. So that was done in an effort by the court to actually try to expedite the situation due to the tax issues. And then also at the summary judgment hearing, Attorney Maureen Kersey did confirm that Mr. Buggs instructed the plaintiffs not to make any further payments. Now, in those payments that the plaintiffs were making, the tax payments were also included in that. And so when Mr. Buggs said to cease any payments, that included all payments. And so, so that's kind of where the plaintiffs stand right now. Of course, they don't want the property foreclosed from anyone, but allowing the injunction to dissolve or to be modified in any way would actually be a grave injustice to the plaintiff, seeing that at the summary judgment hearing, there was evidence produced that showed that all the defendants, in this case, 316 and BPL and FCI, were likely in cahoots to bring about harm to the plaintiffs. And so allowing the defendants, BPL, to foreclose on this property will again be an injustice because they have actually.
So I'm not going to allow the foreclosure to go forward. Obviously, I've done a temporary injunction on that, but somebody needs to pay the taxes, right? We don't want this foreclosed on. And so how do you propose that happen? And understand that with the backlog we have right now, with the year and a half that we had without jury trials, we're going to be, the likelihood you get reached on your trial setting is pretty low. So we just need to, what do we do in the interim? How do we deal with this taxing issue? Because it isn't in anyone's best interest if we if we don't get the taxes paid, right?
Yes, Your Honor. I believe that if we could reach some agreement where every party involved contributes, I think that would be in the best interest of everyone. My clients, I believe I think they will be open to contributing, but I know that they are not wanting to do the entire, especially since they were instructed not to make any further payments. And the fact that evidence was produced to show that the defendants have likely been in cahoots to bring about harm to the plaintiffs, I think they should also be responsible for those taxes as well. Or if not, then I would suggest that BPL look to 316 Capital or Liddell Buggs, who are the actual only individuals or entities that had any obligations to BPL. So if we can't reach an agreement to where we are splitting these things, these costs and interest, I think that BPL needs to look to Liddell Buggs or 316 to take care of those matters.
Your Honor, if I may.
Yeah.
Your Honor, there's been no evidence that the defendants have been in cahoots together and object to anything as to further as that. When Mr. Buggs said not to make any further payments to him, it was to 316 Capital, not to him personally, but to 316 Capital. Did not mean that their obligation to pay taxes under their deed of trust was resolved. Under their deed of trust, they are under obligation to pay the taxes to the taxing authority. The owners of the property are the Anita Alonzo and her spouse, and not 316 Capital. And they've had the benefit and the use of the property all during the time that this matter has been going on. So 316 Capital and the Liddell Bugs would object to them paying the taxes. They haven't received the money to pay the taxes from the Alonzos, and it is under their deed of trust that they were required to pay the taxes, whether or not they made the payment to 316 Capital or directly to Dallas County.
All right. Response to that?
Well, Your Honor, unfortunately, when he stated in court on the record that they were to cease from making any payments, those payments included tax payments. He did not specify, he did not say that they had to continue to make those payments. He specifically said cease from making any payments to 316 until there is a resolution to this matter. So my clients were under the assumption that Liddell Bugs of 316 will take care of any obligations for the property and to BPL. And so although there is a deed of trust, those payments included those tax payments. So Mr. Bug should have been specific in that request or in that demand or instructions to the plaintiffs about making any further payments and that they should be making tax payments. He still has not to this date said anything about them making any tax payments. He has not requested any tax payments. So the plaintiffs have been under the assumption that those things will be taken care of by Mr. Bug since he instructed them not to make any further payments.
Okay, I get that he said that back in 2019, but now we're in 2021. Somebody has to pay the taxes. Your clients have possession of the property, right?
Yes, Your Honor.
And they're taking the position they lawfully own the property, correct?
Yes, Your Honor. However, when initially during their initial transactions, they have put down and paid over, I believe, maybe at the time of the initial hearing, they only had the property for a year, but they put in over maybe about between $80,000 to $100,000, and they put down a huge amount of money for the property. And so we still believe that it will be a grave injustice if they're having to now pay for, yes, they are in possession of the property, but from the beginning of this transaction, they have been wronged by all the defendants in this case. And so allowing them or demanding that they pay all the taxes right now that have accrued and not share in that, I don't think would be fair for them.
I guess the thing I don't quite understand is they're taking the position they own the property, lawfully own the property, the foreclosure is wrongful. Why would the defendants who don't have possession of the property have to pay the taxes while your client has possession of the property? Was there a period of time where I guess my question, is, was there a period of time where the defendants had possession of the property since this all started where they should have been paying the taxes for that period, or did your client have possession the entire time?
The plaintiffs had possession the entire time.
Okay. All right, I'm going to modify this to require your client to pay any past due taxes. I'm not going to require them to put money into the registry of the court, to pay for future taxes, because you're right, this eventually will get resolved one way or the other. But for now, they need to go ahead and pay the past due taxes.
And Your Honor, is there a way that everyone could also contribute to that? Since at the summary judgment hearing, there was evidence produced based on the deposition by Mr. Liddell Bugs that BPL was aware that this transaction was going to be an actual purchase by a buyer and not a flip and fix property. So they have been doing some wrongdoing. And so I think that they also should be able to bear some of the cost of these taxes, rather than it just being all on the plaintiffs. Because at some point, the plaintiffs, if this case is resolved not in favor of the plaintiffs, they will lose all that they have paid down for the property. They will lose what they paid down for the taxes. They will be lost out totally, and not be able to recover those things. And so I think that it would be only fair for all parties to contribute, since there was evidence produced at the summary judgment hearing that there has been some wrongdoing by all the defendants involved.
You kind of can't have your cake and eat it too. Your client has possession of the property. They claim they own it. You claim you own it. we'll work it out at the time of the judgment if they need to get paid some kind of offsets or whatever for whatever they pay. But if they're going to take the position, I've agreed with you so far. I've kept the other side from taking possession of the property. But as long as your client's in possession of the property, then they're going to be responsible for paying the taxes.
Okay, yeah.
And Your Honor, one more thing is there has not been a foreclosure, so they are still entitled to the property.
Right, right. So go ahead. Obviously, the order that was submitted is not correct because you guys had requested, I guess, the payment of future taxes that we put in the registry of the court. I'm not going to require that. I'm just going to require past taxes to be paid. And so go ahead and put together a new order. I think it was Mr. George who put together the original order, if I recall correctly. If you guys can kind of work out an agreed as the form order on this, amending the temporary injunction, and then email that to my court coordinator as well as e-filing them. And on that order, make sure that it says that this hearing took place on July 12th. So at the beginning, instead of on this day, put down on July 12th, just so I can kind of tie it to a day, because with the number of hearings we're getting in and with the system we're using right now, it's a lot easier to be able to tie it if you can put that on the date of the order. Any questions, guys?
Your Honor, I do have one question. In the proposed order that I submitted, it required the payments to the taxing entities to occur within 5 days of the order being signed. Is that time frame okay with the court?
I would say within 30 days.
Okay.
Yeah, can we actually get a bit of an extension on that? Because I think it's I have to look at it, the amount again. But I know that my clients may not be able to, within 30 days, come up with the taxes for 2019 and 2020.
Let's say, instead of saying within 30 days, that they're required to pay the taxes within the time frame specified by the taxing authority, or something like that, to give a little bit of wiggle room.
Your Honor, what if we spread them out, say 2019 in 30 days, 2020 in 60?
Ms. Haley?
That's something I kind of have to get with my clients about, because right now I currently don't know their finances, so I can't say that they will be able to make the 30 days for the 2019 and then 30 days out from there. But I will definitely I can touch base with them and maybe we can follow up on that.
Okay. All righty. Just go ahead and get that done as quickly as you can. I don't have a problem one way or the other. Just come up with an agreed time. And if there's a big problem, just set a new hearing on this. But let's get this signed as quickly as possible.
Okay. Thank you, Your Honor.
All right. Thank you, guys. You guys be safe, okay?
You too.
Thank you, Your Honor.
Thank you, Your Honor.
Flaherty versus Steele. Anyone here on that case? Cause number DC 1916864.
Mike Kramer, I'm here for Western Dairy.
Yeah, Your Honor, go ahead.
Go ahead, Jason.
Oh, yeah, Jason McMahon here on behalf of both plaintiffs.
Judge Hoffman, Gene Ree on behalf of Double C and Alan Waits, also defendants in this matter.
This is Mike Kramer, Judge. Can you hear me?
Can.
Okay, good.
All right, let's go ahead and let's start. So Jason McMahon is the plaintiff's attorney, correct? Mr. Kramer is the defense attorney. Who's the other defense attorney?
Mr. Ree, Gene Ree.
I don't see him on here. Gene Ree. Oh, there, Gene Ree. Okay. And
Yes,
then
Your Honor.
who else is on this?
Well, Your Honor, I've just been notified by my paralegal that Stacy Collins, who is the attorney for State Farm, apparently did not get notice of this. She checked her ProDoc eServe, and this pertains to State Farm's documents. My paralegal's been in touch the last few minutes with her office, and apparently she's on vacation or something. I don't know. I'm thinking we may need to reschedule this, if that'd be okay with the court.
Okay with me if it's okay with everyone else.
I mean, Your Honor, plaintiff's attorney
Your
here.
Honor, that's
I heard somebody trying to talk and I couldn't hear what they said.
Go ahead, Gene.
it's fine with me, Your Honor.
Okay. Mr.
Um,
McMinn?
Yeah, Your Honor, plaintiff attorney Jason McMinn here. The only thing I'll say, I did notice that Ms. Collins in their office was not served with this. They're not part of this litigation, so this is sort of a third-party subpoena. I believe the court was supposed to conduct an in-camera inspection. I don't know if that's occurred or not of this file and what's going to be produced. I do know that we have a trial setting the end of September. This case is set for a second mediation in August. So, there's quite a few things that still need to be done on this case. So I'm okay with resetting it. But I just want to make it clear on the record today that, plaintiff intends to push forward whether or not we get reached or not. This case has been pending for a long time in September. So I just wanted to be clear on that issue.
Do we even need the attorney from State Farm here? Is it required that they be here?
Well, thinking about it, Your Honor, personally, this is Mike Kramer. I don't think we do because the arguments were made on the motion to compel. The court ordered the entire State Farm file to be produced for an in-camera inspection. So it's my understanding at the request of the court, we sent out a notice of hearing just to find out what the court's ruling is.
So we may not need it. So there's a box that was sent here. Is that what I need to be looking for? Okay, give me
Yes, Your
1
Honor.
second. I'm going to pause YouTube and then I'm going to go find the box. So I'll